And so let's find out from Quentin precisely what he can tell us about this particular strange set of arrangements. Quentin, very good morning to you.
Morning, Mike.
Good to talk to you. I've spoken to a few tax lawyers who have explained to me what this kind of implied trust business is. Because when Keir Starmer yesterday or Sunday said to Laura Kuenssberg, I didn't create a trust in order to make this happen, he was sort of right in a way, but in a way he was also wrong, because I'm told that when you do what he did, that kind of creates a trust all of its own, kind of automatically.
Yes, I mean, it completely depends on what the intentions of the parties are. If, for example, I give you something, it's a gift, and therefore it's yours. If I lend you something, if I let you borrow my car for a couple of weeks, it's mine. I've let you borrow it. But in law, if you split the legal title and what we call the beneficial interest, i.e. the right to use it in an unfettered way, then that creates a trust, whether you like it or not, to be honest.
Yes, and that's the point. So he's being slightly disingenuous when he says, I didn't create a trust, because he must know, as a lawyer, precisely what he did. He must know that there was a reason why he didn't gift it to his parents, and he must know why there was a reason, instead of gifting it to them, he loaned it to them. And he must know also, presumably, the ramifications of that.
Well, I mean, most lawyers, or most of us, will have learnt about this in law school, bar school in Keir's case. As to exactly what the position was, you'd have to go into the individual facts of what he had discussed with his parents and what was agreed in order to tell whether a trust had been created or not. Right. But just because a trust has been created, then you go on to look at the type of trust it is and the tax rules, and then apply it to see whether, for example, inheritance tax, capital gains tax, etc., applies to whatever arrangement's been put in place.
Right. Because what we were told was, if he had given it to his parents, or he had gifted it to his father, for example, it would have made his father's estate, which ended up being worth about 300 and something thousand, worth double that. It would have been worth 600 and something thousand, which would have then effectively made him liable for, in some form, an inheritance tax hit. But yeah, a lot of people have asked me, did he pay capital gains tax on it? And I don't know the answer to that. And what would be the rule on that?
Well, from what I've read, he did pay capital gains tax on it when he disposed of it. In respect of the inheritance tax situation, obviously it's very complicated, because you can get inheritance tax banding passed from a spouse to another spouse, from a husband to a wife, for example, which can double your band, i.e. the amount that you don't pay. So that is something that is really quite complicated, and which obviously each situation you'd have to look at the rest of the estate, see what it's valued at, etc. Yes.
And, you know, I've got nothing against people, you know, putting things into trust. I've got nothing against people protecting their assets from paying tax, as long as it's lawful. I just think that a lot of people were slightly shocked that, you know, this government, which talks a lot about people who avoid tax being bad people, even though they're doing it legally, that they're also doing it.
Well, yes. I mean, this government, in common with other governments, has really cracked down on what they see as tax avoidance, effectively, as opposed to tax evasion. Yeah. But you know, the Labour government has been at pains to try to close any loopholes on tax avoidance, as far as I've seen. And if this is a tax avoidance measure, then it could be seen as somewhat hypocritical.
Well, fine. I mean, I don't get to talk to very many cabinet ministers. They don't like coming on my show, but well, I can be for sure the next time I get one on, I'm going to say, you know, is there any trust you want to tell us about? Because obviously we know about the Angela Rayner story and that trust, which was, you know, perhaps slightly interesting in the way that she removed money from it in order to buy another place in Hove. And here we've now got the Prime Minister, who appears to have taken advantage of a trust-type situation.
Perhaps, yes.
It is fascinating. So, I mean, the bottom line, I suppose, is whether people are going to pursue this. I mean, we are, but obviously he spent many, many weeks ignoring questions from the Sunday Times, suddenly said on the BBC this. Let's have a look.
I was a lawyer, I had quite a lot of money, I bought a field for £20,000 at the back of their house, and I said, here's your field, it's yours for as long as you may live, you could put your donkeys in it.
That's because
I didn't create a trust, I simply bought a field, and I said to Mum and Dad, This is for you.
OK.
It was, and also, by the way, Laura, it was £20,000. We're not looking at a vast estate with great tax.
It's a lot of money to many people, and it sold it many years later
It is a lot of money, but
£200,000.
the idea of setting up some complicated trust for a £20,000 agricultural field, which then housed 4 donkeys for all the time my mum and dad. It was my mum. She was able, where they had a little outhouse at the edge of the field, and she was able, in the end, to see the donkeys. And my dad built a little sort of porchway so he could wheel the wheelchair out so she could touch the donkeys. That's what it was for, and I gave it to them.
I
had enough money at the time because I was a lawyer. It was a gift to my mum and dad.
And that's now on the record. You did not put it in trust, and that's not been on the record before, and that is now on the record.
See, I find, and I mean, I know I'm sort of straying into areas that you may not wish to go into here, Quentin, but I find his manner quite strange, you know? He says it was a gift to my mum and dad. Now, being a lawyer, he knows it wasn't a gift, because had it been a gift, it would have been a gift that was gifted, so that it would have been then theirs, right, as you explained earlier. So why do you think he's so kind of inaccurate in the way that he refers to things?
Yeah, the difficulty for me in that is that it seems at one point at the beginning he says, well, it's mine and I let them use it, which might imply loan. At the end he says gift, but then in the middle his language is more akin to a trust. I bought it, but they could use it for the rest of their lives, which implies a split of beneficial and legal interests. So from a lawyer's point of view, I'm none the wiser as a result of that interview.
Right. And that's the problem, because, you know, as a lawyer, and I've known plenty of lawyers in my life, sometimes I've had to employ them for one thing or another, you know, they tend to be fairly exact. I mean, I'm speaking to you and you're being pretty exact with your words. You know what you're saying, you know what you mean, you realise what you're describing could be misconstrued if you say it the wrong way. He doesn't seem to have that kind of, you know, safety valve as a lawyer. He seems to say things which are clearly not perhaps correct.
I suppose there's a difference between acting as a politician and acting as a lawyer.
Yeah, I mean, people tell me, and I don't know what you know of your fellows in the business, but people tell me that when he was in charge of the CPS, he was more of an administrator than he was a litigator. He didn't actually do much litigating in court, and I've spoken to a couple of politicians who actually did work for him at the time as barristers, and he would instruct them, and they would go and take the cases on actually in the courts themselves, and he would sort of sit behind a desk and allocate those cases rather than be, you know, somebody who would actually get up and argue cases.
Well, that's right. In his position, he wouldn't be able to, the sheer workload that he had, he wouldn't be able to go and litigate many cases just because of the sheer amount of things on his desk. But as I understood, I've never myself been in a case with Sir Keir, but his reputation at the bar was one of being an excellent silk and somebody who was very clear and concise, particularly in front of the Court of Appeal and the Supreme Court or House of Lords. He was known to be talented.
Was he? Well, I mean, I find that quite hard to believe, to be honest, because the one thing he doesn't appear to be, in my estimation anyway, is particularly in public speaking, talented. He's wooden, isn't he? I mean, most lawyers I know are pretty good at speaking publicly. They're pretty good at making arguments and making cases. He doesn't seem to be good at any of that.
Well, Mike, you know, the difference between general public speaking and making focused submissions as a lawyer is quite great. I've been to many lawyers' weddings, for example, where the speeches by people who are very talented barristers haven't been very good at all. It's one of those things where the job is quite different to perhaps general public speaking.
Yes. No, I get that. I mean, I've seen both parts of it, you know, but I just don't know. It just doesn't strike me as a very bright spark in the box, really. But there we are. I'll take your word for it, Quentin. Thank you very much indeed. Quentin Hunt, criminal defence lawyer.